I had the opportunity to chat with attorney Jeff Bellomo of Bellomo and Associates about how investors can protect their portfolios from judgment and creditors, as well as how to structure their portfolios so that heirs can continue to receive the cash flow and other benefits. It was a long interview, so I've broken it down into two parts. Here's part one. This program is for informational purposes only. It is not a substitute for professional legal advice. Consult a competent attorney if you have questions about a specific situation. Jeff Bellomo is a Pennsylvania licensed attorney only. All information provided by the program is general in nature and is not, nor is it intended to be, legal advice. Participation in the program does not constitute legal representation, nor is any information provided protected by attorney-client privilege. Okay. Today I have the distinct pleasure of introducing my friend, attorney Jeff Bellomo with Bellomo and Associates. He is Pennsylvania's leading expert in asset protection and estate planning. Hi, Jeff. Jeff, how you doing?
I'm doing well, Paul. Thanks for having me today. Looking forward to this.
Man, I am telling you, I'm working a lot with investors, beginning and more experienced people. And, my whole thing is about building a legacy so that people have assets to pass on to their kids. And more importantly, they have an income stream that they can pass on to their kids. So I wanted to talk with, and I thought there's nobody better to talk with than you about how to structure the portfolio so that they have that legacy that they can pass on. So let's start with talk a little bit about to the beginning investor, the person that's got a small portfolio and they own their properties in their own name. And let's talk about first, tax strategies. What are the tax implications of owning a property in your own name versus in an LLC?
I went several years ago to get my master's degree in taxation, as you know, and I got it from Temple University. And
yeah, I'm still trying to understand that, but okay.
Yeah, and one of the reasons that I went was I could not understand why I would refer a case to an accountant, and seemingly what appeared to me to be the same fact pattern, right? You get a business owner, someone owns real estate, and you send them to two or three different accountants, and you're getting two or three different answers as to what they should be doing from a tax standpoint and those kind of things. And it drove me crazy because I would refer 10 cases out and it would be 5 this way, 5 this way. And, 4 or 5 of them would be exactly the same facts. And so I went to get my master's degree. I got it. I had a very high grade in the class or in the program. I graduated with distinction. And let me tell you something. I still don't know the answer. But what I did learn was that every accountant is very good at something, right? Most accountants have a specialty. Now, a lot of real estate, we tend to use LLCs for real estate for tax reasons in Pennsylvania. But when you're talking about other types of business owners, it's like 50-50 LLC versus corporation. I mean, it ends up becoming a crapshoot. And what I learned from one of my professors was, when you use an accountant, go with whatever the accountant recommends, because that's what they're familiar with and that's what they're knowledgeable with, and they know the ins and outs. So I always like to start with that caveat. Now, typically when we're dealing with real estate, I've always been kind of taught, and I've always seen people do LLCs or use LLCs for that purpose, to try to help not only from an asset protection side, but also from a tax perspective.
Well, one of the things that I find just incredibly interesting about real estate and taxes is that now, is there a difference between the income that comes into an individual is taxed at normal income rates, correct?
Right. Correct.
But if it's the LLC is generating income, that's taxed at a different rate, right? I mean, the corporate rate for an LLC is going to be different than the personal income.
I believe it's slightly different. And then depending on what type of tax structure you are within the LLC, because you could be treated for LLC purposes as a partnership, or you can elect S status, S election, which would then treat it like a corporate, like an S corp, if you wanted to go that route. So there's different ways within the LLC that you can be taxed, and you can effectively make those elections.
Right. And then the other cool thing I thought about with taxes in real estate is the improvement or the building itself depreciates while the value is going up.
Yes, sir.
So we're telling the IRS, nope, sorry, the building's not worth near as much as what I paid for it. So we're going to depreciate that. However, then we're going to go tell the bank and the lenders, no, actually, we increased the rents this year, so the value's gone up. And it's legal. You can use different stories, legal.
Yeah, and you know, the one that I always love too that gets us in the real estate investing world is, I think it's what, the 121 exclusion, that if you live in it as your primary residence for 2 out of 5 years, you can, you know, exempt a gain up to, you know, whatever that number is every year, you know, 500 or so thousand. But of course, when you have a primary residence and you're dealing in real estate, buying and selling, you have the capital gains issue to deal with too. And like you said, you've already depreciated some, all, most, whatever, and now you're getting yourself caught in a tax situation.
And hence why they created the 1031 exchange.
Correct.
And then, but that's a whole different show.
Yeah, we'll talk about that next time. But the complexities are just amazing, you know?
Yeah, and by the way, I went to you guys have, every so often you'll host one of your free seminars for people to come in. And I was there last night with Dan, and I tell you, he is really sharp because he was pulling out things that I knew about, but I wasn't connecting the dots fast enough about, you know, the capital gains and holding your primary residence for 24 out of 60 months. And it's like, yeah, I forgot. Yeah, there's that rule, but I forgot about it. So I was like really impressed with Dan. So that was
really cool. A refresher is always good. You know, if you're not in it every day, it's so easy to forget. And, you know, we offer those things on a weekly basis between York and Lancaster. So typically you can catch one every week in both areas. Never hurts to get a refresh and just hear it again.
Yeah, I'm going to have to make it a plan to go at least once a year, probably 2 or 3 times. But anyway.
Absolutely.
Let's talk about asset protection. I don't think I'm practicing law here by saying that it's pretty well known that investors are encouraged to put their investment properties into some corporate structure. LLCs are the most common, probably because they're the easiest to set up. A couple of you throw up an LLC.
Yep.
Why do we do that?
Yeah, I mean, you know, the simplest reason for me is liability protection or asset protection, meaning if we own an LLC and it's either a rental property or a landscaping company, and we're acting within our landscaping company or rental, and something happens, they cannot come through and come after my personal wealth or my personal assets, right? So essentially, we use bubbles and boxes, and we call an entity or an LLC, a corporation, as a bubble, and your entity is in the bubble, and you're protected from the inside out, right? So they can't get out of that bubble. They can't get out of it to come through to me individually. Now, if I'm owning a landscaping company and I'm in my car and I'm drinking at the bar, and then I drive home and I kill 5 people, well, who are they going to get a judgment against, right? They're going to get a judgment against me, and what can they go after? Anything I own or any interest that I have. So that little bubble was protected from the inside out, but not necessarily protected from the outside in, right? So we want to figure out a way that we can get it protected from the inside out and the outside in, so that people can't somehow attach an interest that I own or come after the interest that I own in the entity. So we use the concept of a radio flyer red wagon, right? And
I love that red wagon. That's great.
I know. And I'll tell you, I used to make fun of it all the time. And I used to roll my eyes, and I would say, oh, that's just crazy. But when you get into a concept and you're trying to teach people something that's abstract and something that they don't understand, this makes sense to them and makes sense to people. So the simplest way to talk about it is, you know, when we were kids, we would carry around these wagons, and we would have rocks, G.I. Joe figures, Barbie dolls. I mean, whatever it was that we wanted to keep close to us, whatever it was that we wanted to keep protected and keep safe, if you will. Now, as we get older, we still keep these radio flyer red wagons. We still put our stuff in the wagons, but instead of it being the G.I. Joe figures and the rocks and the Barbie dolls, Now it's our house. Now it's our rental property, right? Now it's whatever asset we want to keep close to us and potentially asset protected. So remember a very fundamental basic principle of creditor law, debtor creditor law. Whatever you have direct access to, so too does your creditor, right? So a trust is essentially a contract between three parties: the grantor, the person who creates it; the trustee, the person who controls it; and the beneficiary, the person who receives it. So what we always tell people is the grantor is the person who creates it, and they're the ones pulling the wagon, right? They're the ones in front of the wagon, kind of directing it, keeping it closed, deciding what to do with it. The grantor is the one who just creates the whole thing. The trustee is the one who controls it on a daily basis. The beneficiary is the one who may have enjoyment. So what we do with the trust is we put the deed to the real estate in to the trust. Now, we use what is called a grantor trust so that it's still in the grantor's social security number, and the grantor agrees to one thing: they're not going to take the real estate and put it directly back into their name, right? Well, there's your asset protection. Debtor creditor law: whatever you have direct access to, so too does the creditor. I'm not going to put it directly back in my name again, right? So because I'll never do that, I'm giving up that right. I now have that asset protection. I have the right to sleep here. I have the right to enjoy it. And because I'm the trustee, I even have the right to sell it. But what can't I do? I can't put it back in my name alone, right? So let's now imagine that this isn't a box anymore. It's a bubble, right? It's your LLC. Now what we're going to do is we're going to take the LLC and we're going to put it into the wagon. We're going to put it into the trust. So now it's still a grantor trust. So my taxes are still going to be the same. I'm still going to be able to pay it on my individual tax return, my whatever my tax consequences are. But what I'm getting by doing that is I'm getting the entity into the wagon. And because I can't take it and put it directly back into my name, I get asset protection. If the entity is in here for more than 5 years, it's fully protected from long-term care costs. But I could set it up so that I have the right to the income if I want it. I can set it up how I want. I can set it up so that after I die, the trust is in existence, and now maybe my kids get the income stream, but the kids get the asset protected as well, so they can't lose it to their divorce, their nursing home, their car accidents. So the concept of bubbles and boxes is you take the bubble, it's protected from the inside out, you put it into the wagon, now it's protected from the outside in because the creditor can't get into the wagon.